When managing contractual risk, it is important that you understand the impact of a breach of contract, the coping strategies, and the provisions that are available. These are some of the things that you're going to look at, which means that by the time you're done, you should be in a position to analyze the different levels of breach of contract and their impact, compare and contrast the tools and techniques available to resolve a breach of contract, as well as explain different organizational responses to breach of contract. In the other lesson, our focus was on understanding legal and process issues relating to formation of contract. And I hope everything is okay as far as that is concerned. So let's move on. Analyzing the different levels of breach of contract and their impact, that is what you're starting with. So let's say you contract with someone, and in this case, they're supposed to build a website for you. And, well, you have to pay for that, right? So you pay for the website, but instead they don't deliver their end of the agreement. So what you have here is a breach of contract, meaning what? One party, in this case you, has done their end, and the other party hasn't done what they're supposed to be doing in that contract. A breach of contract will open up the possibility of financial damages. And damages in this case just refers to monetary compensation. That is what damages mean as far as the legal, as far as contracts are concerned. Now, does this mean that every breach of a contract attracts some financial compensation? Well, not really. Not every breach of a contract is going to result into somebody paying some money. The degree of any financial damage and additional remedies awarded will vary depending on the type of breach and its effect on the other party. Look at it this way, If a supplier delivers the wrong kind of products, now of course that is going to affect you, that is going to affect that contract. But when you talk about delivering the wrong product, what does that mean? It means they fail to meet specifications. But if you look at it from another perspective, think of it this way. If you order 10 items and the supplier delivers 7, they fail to meet the specification. So in this case, there's some degree of breach of contract. Well, there is a breach of contract. Now, in that case, do you want them to pay? And you're probably thinking, yeah. Now, what if you order 10 and they deliver 12? You order 10, you pay for 10, they deliver 12. Still, in that case, they haven't met the specification because you requested for 10, they've supplied 12. And now they're not aware that they've given you the extra 2. So in this case, what happens? Because it's still a breach of contract, right? They've still failed to meet specification. That is the reason why when it comes to breaches of contract and your propensity to sue for, money, you have to be careful. This is why you need to understand minor breach, major breach, and anticipatory breach. Now, before you jump into explaining what any of those mean, you need to understand that a contract is a legally binding agreement. So the question is always exactly what is it that you agreed on, and that just comes down to the terms of that contract. So here's a quick thing about terms of a contract. Now, terms of a contract simply refer to the obligations, of the parties in the contract, or the duties and obligations of the parties in the contract. Now, these terms can be divided into conditions, which are strong terms, Like if somebody says that I need you to deliver a black, say, they're a black phone. So in that case, color black could be a term of that contract, And well, it is a term of the contract. So the question is it a strong term or not? Well, it depends. If you deliver a phone that isn't black, maybe it's silver, will they take it? If the answer is no, then black was a condition. Now, some other terms are going to be weak, and these are called warranties. So a warranty is pretty much a term of a contract, but it's not a strong term, It's not strong enough to such that it's, if you fail to meet that term, the contract is off. Because that is what happens with conditions. If you fail to meet a condition, then the contract is off. So we have conditions, strong terms. We have warranties, weak terms, And again, as I said, sometimes the difference between these two will depend on the effect in the contract. Now, of course, you can also go ahead and basically classify conditions as condition precedent, which has to happen before the contract continues, condition subsequent, which if it occurs, whatever, the contract is off. The point is, there are a lot of ways that you can classify terms of a contract, but for now, I just want you to remember that some terms are stronger, those ones are called conditions, and some terms are weak, those ones are called warranties. Now, in between a condition and a warranty, there's an innominate term, Okay, so a nominate term, a term whose effect you're not really certain of until it happens in a contract. So it could be one of those terms that you breach it and then it turns out it was a minor term, or it turns out to be a stronger term, which makes it a condition. So that is the first thing you need to understand about breaching contract. You need to understand the terms of a contract and the effect. Because failing to perform whatever that term required is what is going to lead us into deciding whether the breach, okay, is a minor breach or fundamental, a major breach. Okay, so terms, conditions, warranties. Now let's move on. Let us start with a minor breach. Now, a minor breach is a breach of contract that is not that severe. It's a partial breach of a contract. In short, in this case, you've just breached a warranty. Okay, so a minor breach refers to a failure to perform a provision of a contract which does not affect the end performance of the contract in any significant way unless explicitly stated. So let's say you have a contract in which somebody is supposed to deliver something on 5th, okay? And then this one time they delivered it on 6th. So whatever, usually you just want them to deliver on 5th so that you can not worry about them, but you're going to use these things on like 10th or something. So if they deliver on 6th, okay, as opposed to delivering on 5th as the agreement, you see, that is a breach of a contract. But is it a breach that is strong enough to end the contract? No, so it's a minor breach of a contract. Of course, if that habit persists, okay, if they continuously do that, then that changes because now that one becomes a pattern that needs to be fixed. I'm not saying that because there's a breach of a contract and it's a minor one, now you let it go. Remember, this is all about managing contractual risks. So those small breaches, the minor breaches, can end up becoming a major breach. But it's just a question of, do you understand the difference at this point? Is it major? Is it minor? So a minor breach doesn't end a contract, but it can lead to a claim for damage. Now, before you start asking your suppliers to pay for, minor breaches, you need to understand something, okay? You need to remember these things. Number one, the supplier may be in a bad financial position and such claims may make it impossible to finish the contract. Number two, it could affect the relationship you have with that supplier. Number three, the supplier could increase their future quotations. This way, they are covered in case of a claim. I mean, if I'm aware that you have this habit of anytime there's a small problem, you want us to pay for that, then I'm just going to say that, okay, this is how much we are selling this thing. And then in that price, I'm adding some money so that when you start asking for money, remember, sometimes mistakes happen. And so the supplier also has to manage their risk as far as that contract is concerned, just as much as you, the buyer, in this case, also has to manage that risk, that contractual risk. Number four, the cost of pursuing the claim for damage could exceed any compensation or remedy that may be awarded. With all that, then the question can become, what exactly are you supposed to do if there are minor breaches in contract? And yes, we've talked about that, but here's what you need to do. Work with the defaulting party to correct any problem as soon as possible and reduce the likelihood of it happening again. That's the thing you have to be doing with these minor breaches in contract. Now, let's talk about a major breach. And a major breach is actually a material breach. This is a strong breach of a contract, okay? Think of it that way, okay? So it's not like a minor breach that you can just choose to ignore. This one is a strong one. It's a major one. This breach occurs when the action or non-action of a defaulting party seriously affects the performance of a contract to the point where it defeats the purpose of the contract. So, yeah, I mean, in this case, we're talking about somebody basically just violating a condition here. Remember what you say? A condition is a stronger term, okay? So let's imagine a construction situation where a buyer orders 8 new stone pillars to be used on a building project. And the supplier provides 3 partly worn pillars. So that is going to affect that project, okay? It's going to affect the time scale, it's going to affect the design. I mean, we wanted 8, you've supplied 3, and even those 3 are not even up to standard. So you see, that's a problem. That is a major breach, okay? When you break an essential term of a contract, basically a major term, okay, you end up having a major breach of a contract. When such cases go to court, what exactly do courts consider when dealing with this sort of thing? And some of the things that the courts will consider, and again, this will depend, but generally, courts will consider things like the impact of the breach, and that will depend on how that particular breach affects the overall contract. Number 2, how easy it is to remedy. If the breach can be solved using financial measures or a fixed reasonable effort, then the breach is less likely to be considered a major breach. And number 3, how many of the obligations of the breaching parties have been performed to date? And finally, is the defaulting party willing and able to fix the situation? Now remember, the entire thing here, this whole thing is just learning by doing. And so here's a question for you, okay? Look at the following situations and see if you can figure out which one is a minor and which one is a major breach. Number 1, a homeowner hires an electrician to install a lighting system with a specific brand of wiring. The electrician installs the lighting system and it works as expected, but he uses a different brand of wiring. And number 2, a homeowner hires an electrician to install a lighting system with a specific brand of wiring. The electrician fails to install the lighting system. So which of those is a minor breach and which one is a major breach? So remember, it's all about learning by doing, so try and see if you can. And look, if you don't know the answer to any of those things, there's a reason why we have the discussion area. So you can always be like, no, I don't get this particular question. Okay. So yeah, and then we'll talk about it. So let's move on to the next one. Now, the third kind of a breach that you can expect in contract is anticipatory breach. Well, as the name suggests, the contract hasn't been breached, but we think, or the other party has made it known to us that they may not be in a position to actually do whatever they're supposed to do in the contract. So in short, we are anticipating a breach of that contract at a future time. This is anticipatory breach. The effect will depend on whether the breach is repudiatory. Repudiatory breach is a term in a contract which is so serious that it opens up the possibility of terminating the contract. So with anticipatory breach, it's not something that you suspect. It has to be something that you are certain of, meaning it was communicated. Because in any relationship, at some point, you're always going to start thinking, well, is this person as good as I thought they are? So that is not ground for you to just say, that's anticipatory breach, okay? They had some financial difficulties and therefore they can't pay. No, maybe that was just an one-off thing. Maybe they have other sources of income that they can use to continue performing the contract. So there has to be communication in this case. Don't just jump into conclusion. What happens if the party communicates their intention to breach a contract? Now in this case, you will have to start mitigating the risks associated with that particular action. Okay? So you have to, the thing with the contract is that, or rather the thing with breach of contract is that you always have to mitigate these risks. In fact, you always have to reduce the loss. So think of it this way. If you have somebody working in your house, okay, house help or whatever it is, right? And then you come home and you find that one of the tap is running. So you don't take a picture of that and then send them, and then rather you just stand there and wait for them to come so that you can point and be like, what is this? What? No, the first thing you do is you stop the damage, okay? Then you can complain, because if that damage is ongoing, like the water is just running and you are there. So now, as at that time when you realize the damage was happening, to the time they show up, you are part of that, okay? So it's just contributory negligence or something. So you always want to start by controlling the loss. So in this case, since the loss hasn't occurred yet, you want to start by mitigating that particular risk. So that's a thing. Now, think of it this way. Another example. Imagine hiring a speaker for an event and they let you know that they won't make it a week before the event. So do you continue running advertisements with that speaker's face on the billboard when you know that even if people pay to show up for this thing, that particular speaker won't be there? Okay, so here's the thing. If you are really interested in learning more about managing contractual risks, you can head over to zeritnetwork.com, okay? Or you can just check the link in the description and you'll be able to access this entire thing. So let's move on. Now, we know what a minor breach is. We know what a major breach is. We know what anticipatory breach is. Of course, if there's a question, you ask. Now let's compare and contrast the tools and techniques available to resolve a breach of contract. In any agreement, okay, there's always a chance that there's going to be some disagreement in pretty much any relationship, any agreement. And the same happens in contract, except in contract, we just call that one a breach of contract. The method chosen to resolve the conflict will depend largely on the extent to which the breach affects the overall performance of a contract. So when you're thinking about a corrective action, okay, in a breach of a contract, then there are a number of things you have to factor in. In this case, we're talking about things like financial impact, the time available to resolve the conflict, any future aspiration to maintain a relationship with the breaching party, the complexity of the conflict and how easy it would be to find alternative supplier or customer. Now, before we jump into the dispute resolution mechanism or techniques, you need to remember that when it comes to breach of a contract, you have the following two options, okay? So in this case, terminate the contract if the party affected by the breach decides that it wishes to exercise the right to end the contract since the breaching party has not fulfilled their obligation. Remember, these only make sense if the breach is actually a major or a fundamental breach, and you've already talked about that. Number two, affirm the contract, okay? If the innocent party wishes that the contract continues despite a breach by the other party. So it isn't always the case that every time there is a breach of contract, somebody wants the contract to end. Sometimes it's a minor breach and you're like, meh, yeah, I can handle that risk. Let's just continue with the contract. But the thing you have to remember about these two options is that one, the innocent party has to be aware of the options and they have to be willing to take, those particular options. What are the dispute resolution techniques that you can use? So let's talk about dispute resolution techniques that you can use when handling disagreements in a contract. So we're going to start with negotiation. These are a common way, okay? It's one of the easiest, not really the easiest, but the common way of handling dispute in a contract, especially in a situation where you don't want to involve a third party or where you think a third party is just going to be costly. So in this case, you use negotiation, basically negotiate with the other party, okay? The common characteristics of negotiation include it is a voluntary process done with the mutual agreement of both parties involved in the conflict. Number two, the outcome of the negotiation is private and confidential, basically between the parties. But then again, sometimes the parties may decide to make these outcome. They may decide to make it public, especially if it is going to help with public relations. Like, we had a problem with our suppliers, we've resolved the issue, we negotiated a good outcome. If that works for PR, then they can make it public. Otherwise, the results tend to be confidential. Number three, negotiation is typically a quick and cost-effective method to resolve dispute, as there is no need to involve external parties. The parties to negotiation control the process, and of course, negotiated agreements and outcome often lead to a contract amendments that can be enforced through existing law and jurisdiction clause in the contract, which gives the process significance. If you are really that interested in learning about negotiation, again, it's part of the resources that I've added. Okay, I've done an entire course on negotiation that you can actually go through. Okay, commercial negotiation with procurement and supply, and as you're going through that, you're going to learn a lot of things. Okay, and there's going to be video lessons, PDF downloads, practice exercises, so you can check that out. So remember that in every negotiation, the information required when preparing will vary. For instance, what has the supplier's delivery performance been like? Has the supplier been made aware of the specification? So the whole thing about negotiating to solve a conflict will just depend on what is at stake. And so this could be, like, is it an issue about personnel? Okay. Is it an issue about delivery? Is it an issue relating to current agreement? All that stuff. So as part of learning by doing, here's a question for you. Okay. So in this case, what are the advantages and disadvantages of negotiation in dispute resolution? Again, look, with these questions, they're supposed to be, it's just learning by doing. So don't be like, why did you ask the question and then didn't provide the answer? Anyway, so let's move on to the next thing, okay? So negotiation, that's one way of solving conflict. What is the other way? So let's talk about that. In this case, mediation. So just like negotiation, okay? With mediation, it's still the two of you trying to come up with a solution to your problem. Except there is a mediator, a third party who's there to ensure that the process is smooth, okay? That everything, basically this third party is supposed to make it possible so that the two of you can see eye to eye, because there are situations where things are so bad that the two of you just can't sit in one room, okay? So the mediator is there to ensure that things flow, but you too are still going to solve the problem on your own. So a contract might make a provision for mediators as a conflict resolution mechanism and also mention who the mediator will be. So even in that case, you still need to remember that the mediator has no decision-making capacity. That still just relies with the two of you. The parties will have to arrive at a solution on their own. The mediator is just there to guide the process. Remember that. Now, what are the processes involved in mediation? So the process usually will be something like this. So number one, we have, the first phase or the first step will be introduction. This is usually an outline by the mediator who introduces all participants, explains the goals of the mediation process, and encourages both sides to work cooperatively. So the parties might be asked to describe the problem in their own terms and how things have, escalated to the point where now they are. And then the next thing is joint session. So the mediator may attempt to get the disputing parties talking directly about what was said in the opening statements to identify the key issues that need to be addressed. And these, in this case, are just issues relating to contract. Remember, we're talking about mediation as a way of solving problems in contract. So that's pretty much the thing. And then the next thing is private caucuses. So this is where each party has a chance to meet with the mediator privately to discuss the strengths and weaknesses of their position. Again, as you're doing this, if the mediator is good at what they're doing, then they may also, this is where they might also come up with suggestions. They might tell the person, look, but don't you think that if you do this, then that and that, that's the thing. So after that, we have agreement. Okay. At this stage, the mediator is just going to summarize the process, the entire process, and explain how things have been and where we are currently as far as that particular conflict is concerned. If no agreement has reached, then the mediator can advise the parties to seek alternative options like arbitration or going to court. So mediation itself is characterized by the following. So number one, it's a voluntary process and the mediator only acts as a facilitator. The outcome is private and confidential. The process is relatively informal compared to things like litigation and arbitration. And as the process continues, what exactly is the role of the mediator? Of course, the role of the mediator will vary depending on the circumstances, but generally, we're talking about things like encouraging the free flow exchange of information between the parties to reach the best possible position, okay, for all involved, helping parties understand each other's views by summarizing key points of note and issue that may be overlooked, letting parties know that their concerns are understood, identifying and narrowing issues so that the discussion are productive and focused, as well as helping parties evaluate alternatives to ensure that all of them benefit. You might look at that and think, yeah, that's fairly straightforward. The problem with having a third party when you're trying to solve a contractual problem, or indeed any other problem, okay, is finding a neutral third party. That is actually the real challenge when it comes to things like this. The success of mediation depends largely on the personality and skills of the individual mediating, such as the ability to control and lead discussion, their experience, their communication skills, etc. Now, as part of learning by doing, again, by now you're used to the format, right? So here's something that you need to find an answer to. Identify key characteristics of a good mediator and explain what circumstances mediation would be good for. So that's the thing, like, what do you think, okay? What makes for a good one, good negotiator, and what sort of problems that might need a negotiator. Now you have to understand that it's not always automatic that negotiation is going to work. Now, in order for negotiation to work, all parties should clarify their roles and outline their expectations of the mediator to facilitate productive discussion and not provide any binding remedy. All parties should clarify and agree to any special arrangement, especially with regard to confidentiality and the extent to which the parties wish to publicize any part of the process, if at all, because it's not always guaranteed, okay? It's not always guaranteed that we want things under wraps. Sometimes, as we mentioned earlier, sometimes you just want to make these things public for public relation purpose. So we need to agree about that, okay? Next, notes should be taken by the mediator and checked by the disputing parties at the end to avoid any bias or misinterpretation at a later date. And finally, any outcome statement or summary should be produced from the mediator's recording from the process. So those ones are going to help the process. Now, what are the advantages? Because there has to be advantages and disadvantages of mediation, right? So with advantages in this case, okay, the advantages of mediation are talking about things like it helps when the parties are interested in maintaining the ongoing relationship. Remember, you only solve a problem because you realize I have a problem with this supplier or this particular buyer and I'm okay with this relationship. Otherwise, just sue them and take the money and go away. So that's the thing. Number 2, it is flexible. Number 3, mediator can suggest compromise, allowing more resolution options to be explored and considered. Number 4, the process is confidential. And of course, number 5, the process is faster than litigation. So what are the problems? What are the shortcomings of this? Or what are the disadvantages that can result from this? And in this case, mediation cannot produce legal precedent. Okay, remember, this is not something that is, whatever the mediator said is not legally binding. So it's every time there is a problem and you go for mediation, you're just starting afresh. You can't use the results from some mediation you did with some other guy. Like, the way it works in court is that sometimes if there is a case similar to yours and there is a decision, then that decision can just be applied to this case. That is what we call a precedent. In this case, it becomes a declaratory precedent. Okay, so there is original precedent, there is declaratory, there is overruling, there is distinguishing, which is just law anyway. So that doesn't work with mediation. Next, if the mediator has a dominant personality, these can affect the outcome of the process. Number 3, the parties may decide not to comply with the agreement and still go to court. And number 4, mediator has no power to order parties to undertake or refrain from any specific actions. Okay, their role is just to ensure that the thing flows smoothly. So that is the thing with mediation. What exactly is it? How does it work? In order for it to work effectively, what do you require? What are the advantages? What are the disadvantages? And as always, with these things, if there is any question, you ask. You don't sit there with your questions. Okay, now let's move on to another form of conflict resolution mechanism. Conciliation and expert determination, that is the next one. Look, of course, when you have a conflict, as now we know, when you have a problem with the contract, you really want to fix it quickly. But then the problem is that sometimes this isn't possible without the help of a third party. So that is where we end up with conciliators. Okay, so such situations, the conciliation process is used. Unlike in mediation, with conciliation, okay, the conciliator plays an active role. After hearing the concerns of all parties involved, a conciliator will suggest what the resolution should be and propose a non-binding agreement, which is something that is important. Again, you really still need to remember that in this situation, okay, unlike in mediation where the guy is just there to ensure that everybody is given a chance to express themselves, in this case, the person hears the problem, okay, he hears your perspective, he hears the other person's perspective on the problem, and then says, here's what I think we should do. Now, of course, you can choose to do whatever the person has said or not, okay? So again, that's the thing with this one. It's still not legally binding, but the conciliator, at least in this case, is more active than in mediation. Remember, like a mediator, a conciliator must remain neutral at all times. The difference is that a conciliator will work with the disputing parties as an extra partner to help them find the most appropriate solution. So the process, okay, the conciliation process has the following characteristics. Number 1, the process is voluntary and no party is forced to enter into conciliation against their wishes. The process is flexible, it is confidential, and unless you want to make it public, it is confidential. Next, the discussion takes an interest-based approach where the conciliator will try to identify what remedy is in the best interest of the contract, taking into account the legal position of all the parties involved, as well as the financial and legal interests of the parties. And all parties should clarify their role and outline their expectation of the conciliator to facilitate productive discussion and provide recommendations for what remedies can be considered. So that's the thing with that. Okay, the conciliator is playing an active role. So does the process have any benefits? Of course it does, just as much as it has disadvantages. So what are the advantages? Now in this case, okay, the advantages will include things like the conciliator is normally an expert or has good knowledge of the relevant issues. Because, I mean, think about it. If you're going to have a problem and then decide that, or if you have a problem and decide that there's a third party who's going to help us solve this problem, the last thing you want is a third party who has no idea what's happening. I mean, it's an equivalent of, let me make this one social, right? It's an equivalent of you having a problem with your girlfriend or with your wife. And then you go and take advice from some random friend whose only advice is you two need to break up. Because that's it. It's like, why? Then the person says, yeah, I'm single and I kind of enjoy it. So you see, you're not going there because you want to break up. You're going there because you want a problem. You want to know how to fix the problem, not how to walk away from the problem. So the same thing happens with conciliation. You want somebody who can tell you how to fix the problem. Unless, and I get it, unless the problem can't be fixed, then you'll probably go for litigation or something. Anyway, the other thing, the process is confidential. The parties still have an option to seek other forms of conflict resolution if no satisfactory outcome can be achieved. It is more cost effective compared to going to court, okay? And the process is informal and can be tailored to suit the need of the parties involved. And as you've said, yes, it has advantages, but what are the disadvantages? So the problem with this process, conciliation, as a way of solving, contractual problems, okay, will be, so the disadvantages will be, number one, the process is not legally binding, and therefore there is no guarantee of a resolution. Number two, one party may use this method as a stalling tactic. Okay, especially if they know that they don't really care, they just want to. So they can just be there while they're planning their lawsuit on the side. Okay, and number three, a party can withdraw from the process at any time since it's voluntary. So there is a problem with that. So yeah, we know about that. If there's any question you ask, now let's move on to the other way. Okay, the other way of solving a problem. Adjudication is the other way in which you can solve problems. So at times with the contractual problems, you realize that if you take a lot of time trying to solve that problem, you're incurring a loss think of it this way. Let's say it's a construction thing, okay? And you have a problem with your suppliers. While you're trying to figure out how to solve that problem, you have other contractors, okay? Or other suppliers who've already brought things on the site and you have to pay them while the entire project is at a standstill. So you see, you need a quick way, a faster way of solving this problem so that you can move on. So that is where adjudication comes in. Now, adjudication is a process where an adjudicator resolves dispute by reviewing evidence and making decision. The process will usually involve the following steps. So number one, we have commencement, okay? So the process begins with one party notifying the other in writing that they intend to resolve a conflict with the use of an adjudicator. And so that notice that this particular party is submitting, okay, will include things like details of the dispute and the affected parties involved, where and when the dispute first came to light, and the nature of the remedy being sought, and contract details. And then we have adjudicator appointment. So 7 days after the notice has been served, the parties have to appoint a neutral adjudicator because, again, neutrality is important in these things. And then we have referral notice. So referral notice will also be served within days of the notice of adjudication. And this notice is going to detail the case of the party that started the adjudication process and is accompanied by a relevant witness statement, expert report, and other relevant documentation to support their case. So a copy of that is going to be sent to both parties, okay? And then the next thing, what follows? So now we've appointed the adjudicator, we process, okay? So the process has started. So the next thing is responding parties' statement. Because if somebody is going to accuse you of something, you also have to, give you a side of the story. So that is what is going to happen. And this one is also going to be written. Because remember, you're trying to save time. So you write what the problem is. This is a problem. You respond to that problem, okay? And all these things are going to that third party who's supposed to look at them and come up with a decision, okay? So there's that. And what follows is hearing, okay? And again, depending on the complexity of the situation, now we're going to include verbal testimony. Because most of the time we just avoid that because we're trying to make things faster. But there are times when, like if a contract was part written, part verbal, then obviously we're going to expect the verbal part to be, the testimony in that case has to be verbal as well, because how do you justify what you spoke about in writing? Now, moving on, the decision. So based on the evidence that has been supported or that has been submitted, the adjudicator in this case is going to submit their decision. That decision is going to be legally binding. Now, that's important, unlike all those things we've been talking about. So in this case, the decision is legally binding. What are the characteristics of adjudication? Number one, the process is quickly, okay? And number two, the use of a neutral party makes it fair. The decision of adjudicator is legally binding, and the adjudicator is usually an expert, okay, on their field, or in this case, an expert in the given field. So that is important. So since the process has its origin in construction industry, it is best for the conflict arising in the following situations. Okay, so what kind of situation would you want to use these on? So you're talking about things like interim payment, okay, are used as part of the contract, a situation where there is a requirement for time extension to complete work, there has been a delay in completion of work, and final payment is due and is being withheld. So in those cases, you probably want to do that. Now here's a question for you, okay? What are the advantages and disadvantages of adjudication? Again, some of these things are just things you can Google, okay? So right, let's move on to the other one, to the other way of solving conflict in contracts. Now let's talk about arbitration. Now this one is very common, just like a negotiation, except in this case, we are dealing with a third party. And whatever the third party says is going to be legally binding. So unlike adjudication, where whatever the third party says is still going to be legally binding, with arbitration, parties are going to be given chance, okay? A lot of chance to say whatever they have to say and express themselves. And it's not like, you see, with adjudication, you're trying to make things move fast. With arbitration, you're taking slightly more active, okay, approach to solving the problem, while we are still going to do whatever the third party, the arbitrator, says. So the thing has the following characteristics. The process is voluntary, and the parties must expressly state in writing that they all agreed to enter into the process. The process is flexible, and arbitration is usually conducted in private, hence confidentiality. And generally speaking, the outcome is legally binding. Well, unless there is some irregularities, which is going to make it void, okay? It's going to make that arbitral award to be, that's the thing, the arbitral award is that decision, to be void. So, here's something, let's start by a question that you can find an answer to, okay? Learning by doing. What are the advantages and disadvantages of arbitration? So, find an answer to that. Now, look, if you are going with the arbitration process, here are some of the things that you have to factor in when you are looking for an arbitrator. Number one, knowledge of the nature of the dispute and the subject matter, an understanding of the arbitration process and how to conduct proceedings effectively. Number three, impartiality and lack of bias, as well as knowing what is fair and acceptable. Next, the ability to put disputing parties at ease if discussions get heated and escalate. Number five, the ability to communicate effectively, both verbally and in writing. to ensure that there is no misunderstanding and the settlement is clear. That is a thing with arbitration. Look, again, since this is just managing contractual risk, this is not like you're not really studying contract law. So there are things that I'm probably not like going into the details, like what are the characteristics of an arbitral award, what has to be there, things like those ones. You're not really studying to be lawyers now, are you? You just want to understand how to manage risks associated with contracts, okay? But if there is any question, as always, do let me know. Now let's move to the last one, because all these alternative dispute resolution mechanisms were things that you are deciding on, okay? Because you don't want to go to court. But if they all fail, then there is litigation, okay? So let's move on. Let's talk about that. So litigation and legal implication. Let's talk about that. Litigation, basically lawsuit. That's what it is, right? And these are one of those things that you really need to do as a last resort. Why? Because in a litigation, the only person who truly wins is the lawyer, okay? The lawyers involved, because these guys are paid, okay? But the process tends to be quite zero-sum. One person wins, another person loses. And the person who wins, okay, or the person who loses also wanted to win. So it's very distributive. So the thing you have to know about litigation is that the process usually involves parties being present at the same venue for verbal proceedings, okay, rather than written, like with arbitration or with adjudication. So in this case, you have to be there. All of you have to be in court. And that's going to be time consuming, right? Number two, well, the process is rigid due to the procedures involved in lawsuits. And there is no confidentiality in the process. And of course, the judge may not really be an expert on whatever is being talked about. And there is no defined time, okay? There is no defined time as to when the process is going to end. So those are some of the things that you have to worry about when you think that litigation is the only way to solve a problem that you have in a contract. But even with all these, there are situations that are best suited for litigation. For example, where a party is not cooperating, where there is a reputation to maintain, okay? Like if somebody is, like with defamatory statements, if somebody makes a mistake in a contract, they breach a contract, and rather than solving it, they keep on bad-mouthing you out there. So in that case, the problem is not just the breach, there is also your reputation. And so you want to set a precedent. You want to create, or rather you want to warn everybody against making such kind of, like you see these, let's say something like YouTube, right? There are people whose content is just based on saying how someone else is the bad person, scammer, whatever, all this stuff. And you can tell there are those who do their research, and then there are those who just copy the videos and all that stuff. So sometimes, if that was a company, then the company may decide, you know what, that company has done this and you're going to sue them. So in that case, you see, there's a reputation to maintain. Number three, if other forms of dispute resolutions fail. So here's a question for you. What are the advantages and disadvantages of litigation? So the whole point here was just for us to understand some of the ways, some of the mechanisms that can be used to solve disputes in contracts. And so we know them from negotiation to mediation to arbitration to adjudication to conciliation to litigation, all that stuff. So if there is any question, obviously, do let me know. And let's move on. So now let's explain the different organizational approaches to breach of a contract. And so far we are aware of the various ways in which a contract can be breached. So minor breach, major breach, anticipatory breach, all of that. We also have an idea of the various dispute resolution mechanisms that can be used when dealing with contractual breach, okay, or contractual issues. So in this case, negotiation, arbitration, etc. But various organizations have various ways of dealing with breach of contract. And the point is that you need to remember that just because a breach has occurred, just because a supplier has breached a contract, doesn't mean that your customers are understanding. They're like, yeah, I expected this item to be delivered, but because the company I'm dealing with has subcontracted courier company and that company has failed to deliver, it's okay once they fix that problem. Nope, it doesn't work that way. They still expect whatever they ordered from you to get to them when okay, it was supposed to get there. That's the thing. So the guy who placed an order for a car still expects that car, and the fact that your suppliers disappointed you is not really the customer's concern. Now, before we jump into it, rather before we get into the details of all these, let's quickly look at how contracts tend to flow. So we have an end customer or user who needs a product or service. So the customer issues a head contract to the company for the product or service to be delivered. In this case, let's assume that the customer needs some fabric, some t-shirts, okay, some cotton t-shirts, okay? So that's what they want. And so that becomes the head contract. Like, I'm dealing with you and you're supposed to supply me with, t-shirts that I'll probably brand and whatever, okay? So that's what I want. So that becomes the head contract. For some reason, the company may need help fulfilling its obligation, and so they subcontract another company, which becomes tier 1 supplier, and the supplier of this company becomes tier 2 supplier. That's the thing I want you to understand as we move on. So there is a company that you are dealing with, okay, the one that you gave the contract, that becomes the head contract. This company is getting these t-shirts from another company. The company that is supplying them directly, that's their tier 1 supplier. So this tier 1 supplier may also have its own supplier, which is tier 2 supplier. So just have that in mind so that we move on, because we need to look at things like subcontracting and things of that nature. And so it will be important for us to understand the difference between tier 1, tier 2, and things of that nature. Okay, so let's move on. So let's talk about subcontracting. When companies realize that they don't have enough time to deal with a breach of contract and still meet the customer's needs, they may need to subcontract other parties to speed up the process to meet the completion date. And of course, here's the thing you need to understand. When I contract with you, okay, like you're supposed to supply these t-shirts, but then you realize, okay, that you're not going to because the supplier you're dealing with isn't going to deliver in time, then you might decide to subcontract with another person, okay? Or depending on whether you're tier 1 or tier 2, let's say I contracted with you, and then there is this supplier who's supposed to supply you, and that supplier realizes that, well, the person they're dealing with, maybe tier 3, is going to disappoint them. They may decide to subcontract, okay? Have another person deliver the t-shirts so that they can deliver to you, so that they can deliver them to me. Or you, if you're the one who's making them, same thing. Realize you can't do it in time, have someone else deliver. Now, in that entire process, as confusing as it might seem, which actually isn't really that confusing, in that entire process, there's going to be costs. So the question is, who's going to incur this cost? It's definitely not the customer, okay? The reason why you are doing that is because you're just trying to make sure that there is no reputational damage in the process. So that can be your way of dealing with these contractual issues, okay? Some contractual problem by subcontracting. So when deciding whether to consider subcontracting as a response to a breach of contract, you need to know whether or not the product or service is customized, okay, to the needs of the customer, or it is a commercial off-the-shelf kind of product. Now, if it is just something that you're just going to, it's just a off-the-shelf kind of product, then you don't have a problem subcontracting, because the subcontractors are not going to disappoint you. Even if they do, you'll just pick another one. So it's not like if a situation where, let's say, somebody expects you to do a website for them, or somebody expects you to build a certain software for them, and then, you realize you're having a problem, you contract this IT guy, and then the IT guy disappoints you. So the next person you want to be dealing with should be somebody who's really good at delivering whatever it is that the customers expected. See, that is something that has to be customized. That is not the same as when I say I need black t-shirts of a certain size and they have to be cotton or whatever it is. So you say, can you get us black t-shirts? Okay. So other important factors to consider when identifying contractors will include whether the available subcontractors are able to work to the same standards as required in the specifications of the head contract. Okay, remember the head contract, the contract between you and that client. Okay, the first contract that led to all these other things that are occurring now. Number 2, whether the subcontractor has the capacity to work to the required time, quality, and quantity required under the head contract. And finally, the experience level of subcontractors. So subcontracting is one of the ways of dealing with a breach of contract. So what is the other way? Let's move on. Penalty clauses. There is another way that companies are going to be, rather another mechanism that companies will use to deal with breach of contract. And in this case, it's a financial, okay? So penalty clause means you're talking about finances here. And the question then can become, how does this differ from liquidated damages? You see, the thing with liquidated damages is that we decide, okay, of how much the compensation is going to be if something occurs in the contract. So the idea behind liquidated damages is actually to compensate. But with a penalty fines, the motive is not really to compensate, but the motive is to punish, which means the actual motive is to deter something from occurring. And if that thing occurs, then the person who did it has to heavily pay for that. Okay? That's the difference between a penalty clause and a liquidated damage. So remember, again, liquidated damages, okay? If we say unliquidated damages, then that just means the money amount that you're going to be paid will be determined by the court. But with liquidated damage, the amount to be paid has already been fixed in that contract when you're starting the contract. Okay? So like you are supposed to supply something, failure to supply that thing, you pay the other party $500, that's liquidated damage. But then we say, okay, if you breach this contract, then you're going to pay $50,000 when the actual loss in that contract was $1,000. Then you see, you're not just compensating, you're being punished. You find this one in one-off contracts because in such contracts, okay, in one-off contracts, the parties are not that keen on relationship, but they are very keen on performance. Because if you have an ongoing relationship, then the last thing you want to do is make it so that the other party feels they are being unfairly treated in that contract. But if it's just a one-off thing, then it's like, okay, do your part and then let's move on. So penalty clauses. Now here's a question for you. How does a penalty clause differ from indemnity clause? Yeah, we talked about indemnity in previous videos. So how does it differ from a penalty clause? Now, whenever there's an issue regarding the enforceability of a penalty clause, the following will be considered. Number one, the type of breach of contract to which the clause applies. So you really don't want to be putting penalty clauses in minor breaches. Most of these things just relate to major breaches. Number two, the amount that has been identified as payable in the event of the breach. And number three, the amount that would be payable in unliquidated damages, taking into account the need to mitigate any losses that may be incurred. Remember, I've just said, okay, let me repeat what I said earlier. There is liquidated damages, which is the amount that you've determined that is going to be paid as, for compensation, right? Now, unliquidated damage is still an amount that will be paid, except that amount is going to be determined by the court. The purpose is to compensate, okay? But when you talk about penalties, the purpose is usually to punish. So that's the thing you need to understand. So if it turns out that if we go to court, the amount of the court will award is actually less than the penalty clause you are putting in this contract, then it kind of makes sense to just go to court. Now, next, the reason for the parties agreeing to the clause and the intention of the clause. Now, what you need to remember at this point is that since penalty clauses tend to be more than the actual cost of breach of that contract, courts generally tend to not favor them. So that is something that you also need to have in mind when you're inserting one in a contract. Also, if somebody realizes, as I just mentioned, that it's going to cost them less if they go to court, then they'll just say, screw you, we are going to court. Okay? So there's that. That is another way of dealing with breaches of contracts. Organizations can go with that. So there was subcontracting, and now we've talked about penalty clauses. What is the next one? Reputational damage. So there are moments where a breach of contract has more effect. Okay, the effect goes beyond the contract. It goes to the reputation of the organization. So think of a company that sells products, okay, but has subcontracted another company to deliver those products. All right. So this is pretty much what you get with companies like, it's generally what happens in e-commerce platforms. Okay. So you probably buy something online, and then e-commerce company probably has subcontracted couriers to deliver those things. So these couriers are supposed to deliver these things. What if they fail? What if they're doing a bad job? So that shady job that they're doing doesn't necessarily destroy their reputation. Because first of all, you don't even know that they've been subcontracted. The only thing you see is that van, it has that logo, and therefore it must belong to that particular company. So you realize that the subcontractors, or rather in this case, these delivery guys, whenever they breach the contract, they make the main company look bad, the company that has the head contract. So in that case, they're destroying the company's reputation. Reputational damage refers to financial loss that can result from a negative information about a company or individual becoming known to others. So when this happens, the following can happen. Number one, there can be loss of goodwill. This is mostly the case when companies are in the public eye and customers feel cheated. Number two, it may be necessary to make amends to customers and provide compensation for injury or loss of product or service. Now, the way companies will respond to reputational damages will, for the most part, depend on the context, the environment the company operates in, as well as the size of the company. But some of the choices, some of the options they will go for will include things like being honest and transparent with stakeholders as possible. Number two, having contingency plans in place and providing training where appropriate when dealing with external parties, such as the media. And number three, in the event of reputational damage due to a breach of contract with a contracted party, it is best to take an approach that acknowledges the situation but does not place blame on any party until all the facts and remedies have been correctly identified. So the point here was just for you to understand that, yes, we have conflicts in contract. First of all, we have breaches in contract. And what are these? From major to minor breach. And these things can result into conflict. How do we solve those conflicts? Well, we have alternative dispute resolution mechanism, negotiation, mediation, all that stuff. Or you can straight up go for litigation. Of course, it comes at a cost. And then there are also other ways that companies can deal with these breaches of contract, rather than just solving the conflict. So this could involve things like subcontracting, and this could include things like penalty clauses, in addition to other financial remedies that are available there, And also there is the question of reputational damage and what you can do with it. Of course, there are a lot of other remedies that are also going to be available, like specific performance and all that. But it's just a question of the time that is available and, the circumstance that you're operating into. Now, that's the thing with these. If there is any question, let me know, And if you're interested in negotiation, if you're interested in general contract law, all that stuff, I've done courses on that, so check them out. And I'll see you in the next video.